Well, good afternoon, good morning, good evening, depending on where you're joining us from. I'm Brett Waters, and welcome to another in our series of legal considerations for high growth startups. Today, we're going to talk about employment law, everybody's favorite topic. So, as I said, I'm Brett Waters. I've been in Silicon Valley my entire life, kind of a serial entrepreneur. Today, I teach at Stanford University. I'm involved with the Miller Center for Social Entrepreneurship, and I run the Fourth Lee Startup Accelerator. And joining me this morning is Krista Cabrera. Good morning, Krista.
Hello, good morning.
Where are you joining from today?
San Diego, California.
San Diego, California, home of delicious fish tacos.
That is right. The best. The very best.
So, Krista, give us the brief backgrounder on you.
Sure. Let's see. I've been a California employment lawyer for a little over 20 years, which makes me feel very old. My practice focuses exclusively on California employment law issues. I do about 50% litigation, so defending companies when they're sued for sexual harassment, a lot of wage and hour class actions, meal period violations, rest period violations, overtime violations, that kind of thing. And then about 50% advice and counseling. So drafting and reviewing handbooks, drafting policies, and just providing, advice on leave issues, termination issues, that kind of thing.
Awesome. Terrific. And also joining us is Louis Lowe. Morning, Louis. You bet. Louis, your audio is a little funky, but we'll get through it as best we can. So Louis, when you and I meet for lunch in downtown Palo Alto, we typically meet for fish tacos at Sancho's Taqueria. But Krista tells me that the fish tacos in San Diego are actually the best fish tacos in the world. So so Louis, I think this means that you and I are going to have to make a trip down to San Diego sometime soon. All right, excellent. So I was thinking this morning about how, nobody loves employment law, right? I've never heard any company founder say to me, the thing I love about running a company is I love employment law.
Never once.
Never, ever.
Never.
And yet, it turns out to be, if you want to found a company, it turns out to be one of the most important regulatory areas to understand and comply with. It's one of the main things that startups end up getting dinged for and potentially fined for is violations with regard to treating somebody as a contractor when the law says you treat them as an employee or exempt or non-exempt and all these other things. So Krista, if a startup founder comes into your office as a brand new client and says, I'm about to make my first hires, what are the top three things I should know? What would you tell that startup founder?
That startup founder would be very smart. Let's start there. For seeking counsel before stepping into the very, very dangerous seas of employment law in California, or anywhere really. But things are hyper regulated in California.
Right.
So the first thing I would say is do not, without thinking about it and without seeking counsel, start classifying your workers as independent contractors. This is probably one of the biggest mistakes we see founders of startups make. The people working for them don't want to deal with having taxes taken out of their paycheck.
Right.
The founder doesn't want to deal with setting up employees and getting an employee ID number and taking out taxes. And so they think, we'll just make you a contractor, no problem. And I mean, there's a lot of risk associated with independent contractor misclassification throughout the country. Yeah. But in California in particular, there are very rare and limited circumstances where you can appropriately make someone an independent contractor. So that's the first thing I would talk to your lawyer about is, can we classify any of our workers as independent contractors, or do we need to make them all employees? Right. And I hate to tell you this, but 99% of the time, the answer is going to be you really need to make them employees.
Right. And I've done this myself, right? Those first few team members, you tend to want to say, you know what, just just invoice me every month. I'll pay you
Yep.
as a contractor. That way,
Yep.
that way I don't deal with payroll and you don't have to deal with withholding, and it'll be a whole lot easier for all of us. And so I think on the EDD site, I think there's a page that kind of helps you understand the circumstances under which you can pay somebody as a contractor versus the circumstances under which you're required to treat them as an employee.
Yeah, yeah. So the current state of the law in California is there's a statute. It's called AB5, and
Oh yeah.
I mean, basically it lays out what is called the ABC test. You've got to meet three factors A, B, and C, in order to classify a worker as an independent contractor. And essentially, the factor B is where a lot of companies get tripped up. The person has to be doing work that is essentially unrelated to what the company does. So if you've got someone doing the critical work of your company, they are probably not going to be able to be classified as a contractor. And the sort of classic examples you see of a true, properly classified independent contractor is like a retail establishment brings a cabinet maker in to build some cabinets.
Yeah.
Or, I mean, truly like, a law firm brings in a plumber.
Yeah,
or
yeah, right.
who walks around our offices and waters our plants. We're not in the business of selling plants. We're a law firm. I mean, that's truly a contractor. So if you think about it in those terms, it's easy to see, most of the time we're dealing with a problem if we're making people contractors. Now, there are many exceptions to AB5. For example, there's like a business to business exception. So if you are a business working with another business and several independent factors are met, like the business is a true business, it's set up as, an LLC or a corporation, lots of other requirements, the business does work for others as well, then you can fit an exception to that ABC test, in which case a much more employer-friendly test applies, a multi-factor test, and you look at a lot of things rather than this very rigid ABC test. But even if one of those exceptions applies, it doesn't mean automatically you're home free. This person can be a contractor. It just means we're going to apply a slightly less rigid test to determine whether this worker can be a contractor.
Got it. So the first thing is to just really understand the legalities around who you can treat as a contractor and who you're required to treat as an employee, but then the payroll stuff.
That is right.
Great. Okay. So now I'm going to make my now that I understand that, I'm going to make my first hire. And so I meet somebody over a beer, and I say to them, tell you what, come to work for my new startup, pay you 80 grand a year. Do you have any questions? Is that the right way to do it?
I would say once you get through that interview process and you decide you want to hire the person, you're going to want to send them an offer letter. That's what I recommend. You put it down on paper.
So just talking over beer and pretzels doesn't cut it?
Beer and pretzels is great for beer and pretzels.
Yeah.
I would absolutely put it in an offer letter.
Right.
And make it clear that unless you've agreed to something different than this, and sometimes you have to, but 99% of the time, it's just going to be employment at will, meaning you can terminate this person at any time for any reason, and they can resign at any time for any reason. And you want to put that in your letter. I mean, I will say in California and in most states, employment is presumptively at will. So even if you don't say it, that is the case, unless you promised I'm only going to fire you for cause. And if I fire you without cause, I'm going to give you 6 months severance. But it still never hurts to put it in writing. Your employment is at will. We can terminate you at any time, and you can leave at any time for any reason. Right. And then you're also going to want to set forth just the basics, the person's salary, the type of benefits you're going to be providing. And then you're going to want to think about what those benefits are. You can be pretty vague about it in an offer letter. You can say you're going to get the same benefits as other employees. Our handbook will set benefits you get. You don't have to really get into everything in the offer letter, but you do want to think about the fact that, depending on where that person works, there might be a sick leave statute or ordinance that you've got to comply with. So they've got to,
Right.
maybe 3 days sick leave if it's certain parts of California, more if it's other parts of California. So you're just going to need to think about the types of benefits you need to give them. One way or the other, refer to benefits in that letter, and then there are some, you've got to tell them that they're going to need to be able to show that they can work in the United States. Just a few basic things you're going to want to put in that offer letter.
Right. Right. So to me, one of the key things there is the at-will thing, that, it's very important to be explicit about the fact that this is an at-will employment relationship, meaning, as you said, meaning that you can quit at any time and I can fire you at any time.
Absolutely. And I think another thing you want to be really clear about in that letter is the salary. One, if we're sort of talking about sort of like the three big things where startups can get in trouble. Another one is with exempt misclassification. We talked about independent contractor misclassification.
Yeah.
Another issue we see is treating everyone as just a salaried employee, not making anyone track their time, not thinking about meal and rest breaks, not paying overtime, not really thinking about minimum wage.
Because I got to start up. I don't want to deal with tracking time and all that crap. I just want to pay everybody a flat salary. Why is that not okay, Krista?
That is fine and well if the person you're hiring meets the appropriate requirements for being what we call an exempt employee. And when I say exempt, I mean exempt from overtime, essentially. Exempt from the types of rules that apply to hourly employees. It's fine if, number one, you're paying the person at least 2 times the minimum wage. There is a salary threshold. So you can't pay someone $25,000 a year and call them exempt. They got to be paid at least 2 times the minimum wage. And number 2, they've got to be doing what we call exempt work. And there are, certain, and this is another, the EDD website that you mentioned earlier will lay this out. The Department of Labor, the California Department of Labor website will lay this out as well. But, I would obviously suggest you seek counsel on this. You're going to need to figure out whether they meet one of these exempt tests. So there's an executive exemption that could apply to your C-level employees, folks that are overseeing a department or the entire company. There's the administrative exemption that applies to people doing, white collar work. So there are various exemptions that can apply. One through line for all of them is the work has to require independent discretion. So they've got to regarding matters of importance to the company. So this can't be someone who's just doing data entry or just taking directions. To properly be exempt and just be paid a salary and no overtime, you got to be doing really important work that requires thought, that requires analysis, in addition to fitting one of these particular tests and making at least 2 times the minimum wage. If you don't have that, you do need to pay these people by the hour, give them overtime, track their time, all of that fun stuff.
Right. So if anybody in our audience is not familiar with exempt and non-exempt, I highly recommend you just Google it. Google it right now or make a note and Google it later. That this concept of exempt and non-exempt is a really important concept to understand. And that, as Krista said, there's a variety of kind of tests for whether you can treat somebody as non-exempt or whether you have to treat them as other way around. Whether you,
it's
I know.
intuitive at all.
Louis, let's test out your audio. Still no good, Louis. Still no good. So we're gonna leave you in viewing mode for the moment, and Chris and I are going to continue our conversation. Okay, so Krista, let's see. So we covered at will. We covered exempt and non-exempt. We covered what was the first thing we covered? We covered independent contractor. Independent contractors versus somebody who you need to treat as an employee.
Yep.
So Krista, I got a startup. We want to conserve cash. And so, me and my co-founders and everybody, we're working for free right now. Cause we got to get this thing off the ground. Any concerns there?
Major concerns. And we see this all the time. You got to pay people to work for you. Otherwise, it's basically indentured servitude, and that is a no-no. I know this is such a typical scenario with young startups. Like, let's just with sweat equity, we're going to work for free, we'll get paid on the back end, and that just is not, it's not compliant with the law. And the problem is these types of people who are starting companies, usually are higher level. So you can't just say, okay, fine, I've got to pay these people who are sort of getting the company started, I'll just pay them minimum wage. I mean, you could do that. That's fine. But then remember, you've got to deal with, they've got to track their time. They've got to take meal breaks. They've got to take rest breaks. You've got to pay them overtime. You're not going to want to do that usually with really high level people starting a company, which means you are going to have to pay at least 2 times the minimum wage.
So are there any workarounds for this? Because like I said, we want to conserve cash. We don't want to be paying anybody any money.
There you can potentially, and this gets a little more into business law, so I get nervous. I don't like to dabble in areas where I'm not an expert, but I will say I think you could potentially, if the business is an LLC, and the people doing the work are members, I do believe you could potentially have their membership interest be their compensation. But I would say you're really going to want to talk to a combination like business lawyer and employment lawyer to see about whether that is workable.
Right.
For the most part, really, there isn't a workaround. You do have to pay people who are working for you.
Brent, I'm going to take another shot at the audio here, and I hope that's
okay. Louis, your timing is perfect, Louis.
Well, so the way
I just mentioned business lawyers, and you magically appeared.
Yeah. The way I see it, there are 6 times that a founder needs to think about employment law, or in 6 kind of audiences. And the first is typically when we hear about a startup, generally somebody is working for another company already. You're working for Hulu, the mythical company on the Silicon Valley TV show on HBO, and you've got a startup idea, and you've got to think about what are my obligations to my current employer, and your new startup should be done on your own device, personal device, not a work device. It should be done on your own time, and you've got to be very careful about overlapping areas of expertise and product roadmap, because that is a recipe for disaster if you try and take your current employer's idea and spin it out into your own startup without their permission. So that's the first area. The second area is when you start your new company, you've got to recruit other founders. And they're going to need some sort of compensation. They're going to want some sort of a title, status, position. Then after you've formed your company, your investors, you're looking to raise money. And your investor is going to go look at your setup, and they're going to say, is this safe? And they're going to want to see that to some extent there's been at least nominal compliance with employment laws, because no investor is going to want to buy a class action lawsuit or a dispute between founders, or a dispute with a prior employer. So when I'm investor counsel, and again, we work with hundreds of companies in the emerging growth space as well as investors, we're looking at those areas. I would say, as you're moving along in the life of your company, you've been funded, you exist, you're kicking butt, and you're hiring people. You're then worried about, are you paying your payroll taxes? Is everybody on payroll properly documented, as Krista's noted? Have you made sure that they're all eligible to work in the United States, or have you gotten a proper visa? That sort of thing. Next, you have the government, and that's a constituency who's going to be checking that you're declaring the proper amount of employment tax, and you're taking care of things. And then finally, when you go to sell your company, or go public for that matter, have some sort of an exit, you're going to have a lot of eyes on everything you've done up to then. Yeah. And that's a point where you can lose a lot of value if you haven't done this right. It's the first place where a buyer is going to say, well, geez, I'm going to need to take a 10% holdback against the purchase price to cover any indemnity issues that I might have with the government, or with a former employer, or or with employees. So that's a big potential area. And then after you've sold the company, I would say failure to comply with employment issues is the number one area where we see post the M&A claims against sellers.
Right.
So the buyers go ahead and buy your company. You're feeling great, and then suddenly you start to get notifications in your email box that money is being held back against that escrow that you gave, and it's clear you're never getting it back, because if buyers start to do an investigation or start to study this thing, that means that there are people on the clock, taxi meters are running, and that means it's hitting your bank account.
Right.
So Brett and Krista, those are the areas kind of that I see, and I think there were 6, maybe there were 7. I lost count. Not good at counting anything more than tacos.
No. Yeah.
It's
Yeah.
the problem with lawyers. We're not good at math.
No.
I love what you just said, Louis, and it got me percolating on a few more sort of necessary things to do as you grow. An employee handbook is something that companies need as they grow. Listen, when you're just starting out and you've got, I don't know, 3 employees, just the basic policies that are required under the law, fine. You've got to give people, you've got to have a harassment policy. You're going to want an EEO policy. There are some very basic policies you're going to want to have in place. But as you grow, you really are going to need a whole full-blown handbook, because in California, the minute you get above 5 employees, a lot of these laws start kicking in. The CFRA, which is the California version of the FMLA, meaning you're going to have to give people up to 12 weeks of leave for, family medical leave. The pregnancy disability leave law is going to apply right away. So you're going to need a policy explaining how that works if any of your employees become pregnant and need time off. So you really do want to pretty early on start thinking about getting just a real basic handbook in place that covers all of those various policies. And and the other thing, and I know this is sort of venturing a little bit into the world of IP, but another thing you're definitely going to want to have either in your offer letter or as a separate document that you present to your new employee with your offer letter is a proprietary information and invention assignment agreement, a PIIA or PIA, or there's lots of different words, lingo to use, but basically a document saying here is what we consider proprietary. You may never take this information. You may not use this information other than in connection with your work, and anything you invent while working for us, you assign to us. It's going to be important to have that as well.
Right.
I want to go back to something else that you asked, Brett, and that is, what do you do if things aren't perfect? Oh my gosh, it's the real world, and you don't have money to pay all these people 2x minimum wage, and you don't have a break room. You don't have a ping pong table. You don't have a dog. You don't have $1.
That's right.
And
no
what do you do?
no free tacos at lunch.
No free tacos at lunch. And, I live in this world with a lot of our early stage, seed stage, pre-seed stage companies. And, we do our best to make sure that we're doing as much as we can to comply. And where we're not, we're trying to make up for it later. We're compensating people with equity so that certainly they won't feel like they've been shortchanged if things get better. We make do, and that's something of an art rather than a science. And it doesn't mean that it's okay not to comply with the law, but I will say that there is the real world of reality that many startups are in, which is that they don't have cash to do these things, and you move along.
Louis, can we accrue wages against a promissory note? Is that kosher? No. Krista's shaking her head.
I will just say, could you do it? Sure. Is it technically legally compliant? No.
Okay. Yeah.
Have I seen it done? Many times, unfortunately.
Okay. Yeah.
And it resulted in indemnification claims when we discovered it later, and the buyer discovered it and charged the sellers for the liabilities that accrued. So, of
Right.
course, the problem, Brett, with accruing a note is that you're failing to pay the payroll tax as and when they come due, and you're not complying
Yes.
with the law.
Yes. There is
And so
that
again,
problem.
you have an
Right.
issue with the employee, you have an issue with the government, you're going to have an issue at some point with auditors if they're auditing your financials, which probably doesn't happen until after you
Right.
sell the company or go public, and
Right.
then you will pay for it times
Right.
multiples of what you did.
Right.
That being said,
and then you'll have a problem with your spouse.
Yeah.
But we see these problems all the time, and we come and we deal with them, Brett, and so I don't want anybody out there to panic.
So Robert asks a really good question, which is, do the founders have to sign a PIA? Is
That's the most important document of the entire startup, right there.
Yeah.
It is a great question.
It's a great question.
I have a binder in front of me right now. I've got a case where the founder didn't. I mean, he founded the company. He made everybody else sign one. He didn't. Founder needs to sign one.
Yep. So, and this is a good segue into kind of something you touched on earlier, Louis, which is, so you've handled a lot of venture capital financings in Silicon Valley and beyond, and in any financing, there's due diligence that happens, and in every due diligence process, all kinds of skeletons come tumbling out of the closet. And so, Louis, in your experience, how often is it that one of those skeletons has something to do with employment law compliance?
I'd say it's the number one issue that we come across in due diligence of any kind.
Right.
And if you're on the company side, you're going to want to disclose it. If you're on the investor side, you understand that that's an issue whether you see it or not. You're not going to want a disclosure because that's going to hit your ability to get an indemnity later on down the line or to recover for it somehow. So what do you do? Well, again, I think you do your best. And that's a very deep question, Brett, that would require many tacos and maybe some cervezas with the tacos.
Yeah, they go well together, it turns out. Yeah. So, yeah, I think this is, to me, this is kind of the message for the three of us to communicate to the various founders on this call today is that, running a company is hard enough as it is without running into kind of unexpected compliance issues and unexpected employment law issues. And so, my experience is get this stuff right the first time and keep it buttoned up. And if you do that, if you make the effort to do offer letters, make sure everybody's at will, make sure everybody signs their PIAs, make sure you understand exempt versus non-exempt, contractor versus employee. If you do all that stuff up front, then you will find all of your financings and other transactions will go a whole lot smoother.
Brent, I wanted to make a note on that, and founders ask me often, how do I do this? I've raised $1 million. Literally, how do I open payroll? And in the last 5 years, there's just been a huge acceleration in the quality and accessibility, I would say, of technology tools to go do this for you. And one that I recommend often is called Gusto. And they provide not only payroll, but they can provide some benefits, some minimal benefits, and then they can help you build better benefits as you go along. And it's very easy to do yourself, manage it yourself, kind of in the cloud. Paychecks is another that we see, which is maybe for a bit larger company. There's TriNet and there's many others. We don't have any preferences, but people like Krista and myself who work with startups every day are happy to help founders navigate that. I would say ask your co-founder friends as well what their experiences have been and what they like and didn't like. And coming back to something you said, Brett, about how to set this up right, you've heard me say this before. We see startups all the time that have three big problems. One is they need money. Two is they need a legal structure to get that money. And three, they need a financial structure to manage the money. And I would say that doing all these sorts of things fits in that third bucket. You could call it financial, operational, HR, whatever. It's one bucket. And when you're building your co-founder team, sometimes we see the one founder, the CEO, the chief everything officer takes everything on herself or himself, and that's fine, no judgment. And then other times, if you've got a group of several of you, make sure that you've spelled out the roles, that somebody is making this their responsibility to do this. Or, I think that there are some fractional CFO firms or fractional CFOs that do a really good job of navigating the kind of 0 to 1 phase of a startup, getting this stuff off the ground, and you can always improve on it later. And with that, Brett, I'm going to turn it back to you and say thank you so much for bringing us all together again for one of these conversations.
My pleasure, Louis. So we have one last question here that Akshita wants to get in, which is, so we've talked about exempt and non-exempt. So, should we just treat everybody as non-exempt? Is that the right way to go?
Right. Yeah, I see that question. And she says, what's the downside of having non-exempt? So the downside is it's absolutely the risk-averse way to go. Yes, right? We're just treating everyone as non-exempt, and they're all hourly. The downside is now you've got to properly track their time. So if your employees are non-exempt, they must clock in the minute they start working, clock out the minute they stop working. They must be paid overtime now. So if they work over 8 hours in a day, in California, we have daily overtime, or over 40 hours in a week, they're getting time and a half. Once they get to, it's like over 12 hours in a day, or, certain thresholds, it becomes double time. You've got to make sure they take compliant meal and rest breaks. There are penalties if they don't. And you could have potential off the clock issues. Like if these employees are working at home, let's say, and they don't record that time, they could come back to you later and say, oh, but I did all of this extra work you didn't pay me for. And oh, by the way, it was at an overtime rate. So they're just, compliance is very, very challenging with non-exempt employees. It's absolutely what you've got to do if employees truly are doing non-exempt work. But it's not a choice most companies would make voluntarily.
Right. Excellent. Well, our time is just about up, but this has been a great conversation. Kristen and Louis, thank you very much. I think, this is obviously a highly complex topic, and the fact that, in 30 minutes, you guys gave us a nice kind of overview is terrific. And I think maybe it'd be great if we could do another one of these, Kristen, where we go a little bit deeper into the harassment stuff, because
absolutely, I'd be happy to.
That's a big topic of its own. I know Stanford makes me, take harassment training every year.
Yep.
And they have proof that I've gone through the course, and it's a big issue these days. So maybe we'll do another one just on that.
I'd love to. I'd be happy to.
So in the meantime, startup founders out there, here's the way I think about this. Many of you are technical people. Many of you are engineers. And so you know the term technical debt. So technical debt means you've had a team working on this software for a couple of years now, and there's a whole bunch of duct tape and baling wire that holds together various aspects. And you keep meaning to go back and address it, but of course, it just kind of gets worse and worse and worse. That's the concept of technical debt in the engineering world. And that same concept applies to the discussion we've been having here today, that every startup, begins kind of semi-compliant, but you don't want that to start building upon itself to the point where you realize a year or two in, you are so out of compliance that you're going to have real problems, not only with regulators, but also with investors. And so best to get on top of that stuff early, I think, is the bottom line for me in terms of advice for startup founders. Kristen, Louis, thanks again. See you soon.
All right, bye.